Okay, so needs very little introduction, but I'd like to, is Mark Rumold here? There he is, thank you. Mark is from the EFF. His talk is titled Through a Prism Darkly, so I'm going to leave it with that.
Good morning. I'm Mark Rumold. I'm a staff attorney at the Electronic Frontier Foundation. And before I get started, what I'd like to do is, I was wondering if I could get a quick show of hands of people in the room who are familiar with EFF and the work that we do. Okay, that's great. That's really reassuring because you all in this room are the core of our membership. I told a colleague that I work with that I was coming to speak at NANOG, and he looked at me and he goes, "Oh, real geeks, nice." So it's great to be with you all, and geeks really make up our membership. For those of you who don't know about EFF, we're an organization dedicated to protecting and defending civil liberties in the digital world. So we're a team of technologists and attorneys and activists, and we work in the courts and in Congress and in legislatures and to educate the public and elected officials about kind of the threats posed by civil liberties, or posed by technology to civil liberties. Excuse me. Civil liberties are a good thing. I hope to reinforce that during this talk. The threats that technology pose, and also the benefits that technology presents for civil liberties. But I'm here to discuss NSA spying. And what I'd like to do today is kind of just provide a broad overview. And so I'd like to start by playing a clip. For those of you who've been following the scandal at home, you've probably seen this clip. Maybe not the full question and answer, but this clip I think really establishes some of the themes that are going to recur throughout my talk. Oh, and this is from the Senate Select Committee on Intelligence from March 2013.
I thank you, and just for you, Director Clapper, again on the surveillance front, and I hope we can do this in just a yes or no answer, because I know Senator Feinstein wants to move on. Last summer, the NSA director was at a conference, and he was asked a question about the NSA surveillance of Americans. He replied, and I quote here, "The story that we have millions or hundreds of millions of dossiers on people is completely false." The reason I'm asking the question is, having served on the committee now for a dozen years, I don't really know what a dossier is in this context. So what I wanted to see is if you could give me a yes or no answer to the question, does the NSA collect any type of data at all on millions or hundreds of millions of Americans?
No, sir.
It does not.
Not wittingly. There are cases where they could inadvertently, perhaps, collect, but not wittingly.
So on June 5th of this year, the general public became abundantly aware that what General Clapper just said to Senator Wyden was false. But what's important, before I go on, what's important to know about that conversation was that Senator Wyden wasn't asking that question for his benefit. Senator Wyden had served on the Intelligence Committee for 12 years. He knew the answer. He knew about the call record collection program that was essentially collecting the call detail records of millions of Americans' phone calls. He was asking that for our benefit. And so when General Clapper lied to Senator Wyden, that was not a lie to Senator Wyden. That was a lie to all of us that were not fully briefed on the program. But on July 5th, The Guardian published an article with an order from the Foreign Intelligence Surveillance Court that made clear that the government was collecting millions and millions of phone records about Americans. On June 6th, the Washington Post published an article that disclosed the PRISM collection program. I'll describe it a little bit more later on, but those two articles started a series of articles that have come out over the course of the summer, and they can be, even for someone like me, whose job it is to keep track of this on a day-to-day basis, it can be very difficult to stay on top of what the latest disclosures meant and what the latest disclosures were. So what I'd like to do today is kind of provide a broad overview of what we know, but I'd like to start by giving a little bit of background. And I think the background sets us up to better understand what we know, and also to understand what the problems are with the NSA's surveillance. And then we'll also talk a little bit about what the EFF is doing, and hopefully also about what you all can do too. We'll cover a lot of code names and a lot of acronyms and a lot of section numbers. These are the this is the currency of attorneys. We like to keep our things as confusing as possible, so to protect our guilds. But I'll try and provide a little more information for you all so that you can better understand what's happening in the news. So to start, I'll start with the background. I'm actually going to skip a few slides because I think I've tried to pack a little too much content into this. But so changes over time, technology, and laws have really changed the focus of the NSA from this outward-looking organization focused on foreign intelligence collection to an agency that firmly has its grasp on the domestic networks of the United States. And while there have been some changes, a lot actually surprisingly has stayed the same over time. And so I'll try to highlight areas that have changed and areas that have stayed the same. So this is what I'm going to skip over a little bit. NSA was established in 1952. Until about the 1970s, the NSA kind of quietly did its job. I don't think the American public knew much about what the NSA was doing. But then in the 70s, there were a series of articles that disclosed that American intelligence agencies had surveilled dissidents and domestic radicals, quote-unquote radicals, that were opposed to the Vietnam War or suspected of communist sympathy. And then there was also Watergate, and Watergate also disclosed, political surveillance and illegal conduct on the part of the executive. And that spurred both houses of Congress to establish committees to look into intelligence agency behavior. One of those, the committee in the Senate, was the Church Committee. And it disclosed for the first time, really, kind of the NSA's programs and the effect that it had had on Americans. Two programs, Project Shamrock. The NSA obtained the international telegrams of American telegram companies going in and out of the United States. They obtained them all and searched them all for foreign intelligence information. Another program, Project Minaret, resulted in the surveillance of such radicals and threats to national security as Senator Frank Church, Muhammad Ali, Martin Luther King, Robert Redford. And so the Church Committee disclosed this to the American public for the first time. And Senator Church, this is from 1975, and it seems eerily prescient today. The NSA's capability at any time could be turned around on the American people, and no American would have any privacy left, such as the capability to monitor everything. Telephone conversations, telegrams, it doesn't matter. There would be no place to hide. So after the Church Committee, Congress enacted a series of reforms, the first of which was permanent oversight committees in the Senate and in the House. The second was the enactment of FISA, which you'll hear a lot in the news today. FISA, for the first time, required intelligence agencies to go to a secret court that was also established by FISA to get a warrant to conduct national security surveillance within the United States. It still allowed the intelligence agencies to do whatever they wanted overseas, but so long as the surveillance was happening inside the United States, they had to go get a specialized warrant. But changes in technology changed the NSA's focus. Originally, they focused on intercepting communications from satellites, but as you know, technology started to change, the NSA shifted its focus to fiber optic cables. In the 1980s to 2000s, the NSA kind of built out this domestic network for intercepting communications passing over cables. But the problem was that FISA was designed with the interception of satellite technology, or satellite communications in mind. So FISA gave the greatest protection for surveillance that was done within the United States and surveillance that was conducted on a wire. Because when FISA was passed, most domestic communications were transmitted by wire. The build out of this domestic surveillance apparatus, the government often phrases in terms of America's home field advantage. So you all probably know better than anyone else, perhaps in the world, that much of the world's communications pass through the U.S. on their way to their intended destination. So if there's an email going from Europe to Asia, it's very likely going to pass through the United States. So during the 80s to the 2000s, this domestic infrastructure was in place. After 9/11, President Bush basically authorized the NSA to open the spigot, to start a domestic surveillance program, unlike anything the NSA had ever done. The program that President Bush authorized included the collection of domestic content, international content, domestic internet metadata, and domestic call records. It was called the President's Surveillance Program, or the PSP. Its code name was Stellar Wind. You'll hear these often in the news. And it was implemented without any court involvement, and it was implemented without consulting Congress first. At the same time, the executive did go to Congress, and they were able to pass a series of reforms to surveillance law, national security surveillance law. It was called the Uniting and Strengthening America by Providing Appropriate Tools Required to Intercept and Obstruct Terrorism Act of 2001, also known as the Patriot Act. And crucial in the passage of the Patriot Act was a section called Section 215. I'll touch on that a little bit more later. I'm actually going to skip over this, but in 2004, a number of very high-level Department of Justice officials almost resigned over the program, including the director of the FBI. There was a showdown in a hospital where Attorney General Ashcroft was recovering from surgery, and Alberto Gonzales, White House counsel, was trying to get him to reauthorize the program, but he was too drugged out to do it, so there was an acting attorney general, and then it nearly resulted in the resignation of a number of high-level officials, but tempers cooled, and essentially the program continued. In 2005, the New York Times broke for the first time that President Bush had authorized the NSA to intercept the communications of people within the United States communicating overseas without a warrant. Now, the Bush administration did a crafty job here, and they gave this part of the program a special name. But in reality, they called it the terrorist surveillance program. Who could oppose terrorist surveillance? No one. But in reality, this wasn't a special aspect of the program. It was just the only aspect that the New York Times disclosed. So the debate on the NSA's spying was necessarily limited to this narrow window between people communicating with al-Qaeda overseas, when in reality there was this larger program churning in the background. in 2006, AT&T disclosed that the NSA was maintaining a massive database of Americans' phone calls. This is exactly the same story that The Guardian broke again in June of this year. But again, the Bush administration decided, actually they never even squarely addressed the allegation raised in the article. They just pretended like it never happened and it was swept under the rug. So in 2008, the executive finally went to Congress and they said, we need to amend FISA, the law that was passed in the late 70s. This was called the FISA Amendments Act. And it did two primary things. It gave the telecom companies that had participated in the rollout of this domestic surveillance program, it gave them immunity for their participation. EFF filed suit against AT&T on behalf of AT&T customers in 2006. And that lawsuit was killed by the FISA Amendments Act. The FAA also created a new type of surveillance that the NSA could engage in. And it was a carve-out to the original FISA, where the NSA could, inside the United States and without a warrant, conduct surveillance directed at people overseas. So to just kind of give you a quick background on the differences. So the old FISA, you had to have a specific target in mind. You had to go get a specific court order for that target, and then you could conduct surveillance within the United States. Now with the FAA, there were no specific targets. The court didn't sign off on the surveillance of any one individual, but it signed off on broader programs of surveillance. And the surveillance had to be targeted at people living overseas. And all of this was done by a court, the secret FISA court that was established in the late 70s. Originally, under the original FISA, the court would simply get an application for a warrant to conduct surveillance, review the facts supporting that warrant, and sign off on it if the facts supported it. That's what courts do all the time in the regular criminal wiretapping context. So courts are capable of doing that, and they're capable of doing that in secret. Now, but what changed with the FISA Amendments Act is that the court was no longer in a position where it was signing off on a review of facts and whether there were probable cause to support those facts. What it was doing was signing off on broad programs and interpreting the law in sometimes the Constitution, the FISA Amendments Act, other laws prohibiting wiretapping, and doing it while only receiving one side of the argument, the government's side, and doing it in secret. So there are interpretations, and there continue to be significant interpretations of law that are entirely secret. So to quickly review, FISA is the old one, individualized warrants, individualized orders. Patriot Act, Section 215, I'll discuss that a little bit later, but that's what the government relies on to collect call detail records. The FISA Amendments Act created a program of broad domestic surveillance intended to target people overseas. And Executive Order 12333, I actually didn't describe that, but that just is kind of the gap filler. It's what the NSA uses to conduct wiretapping outside of the United States. So now with that background, and I hope it wasn't too heavy, now I can get into a little bit of what we know and what the programs that have been disclosed, how they function within the law. So the first is FISA Amendments Act, Section 702 surveillance. The government conducts two types of surveillance under the FISA Amendments Act. It It does upstream collection, what it calls upstream collection, which is collection of communications on fiber cables and infrastructure as the data flows past. And then the other type of collection they do under this law is the PRISM collection, which is the collection, this slide, according to the companies, has misrepresented what happens, but collection from the servers of these U.S. service providers, Microsoft, Yahoo, Google, Facebook, Paltalk, AOL, etc. So these are the providers that participate in PRISM, and this right here represents my best understanding of how the PRISM program actually works. I don't think that PRISM allows the NSA direct access to the servers of Google's, Microsoft, etc. I think actually PRISM is something of an interface that the NSA uses to task specific queries that are then passed on through some type of process to the companies themselves, and then the companies, after, if there's some amount of review of the specific queries, that information is then passed back to the NSA. But I don't think it gives the NSA carte blanche to search whatever, whenever they want. Although I could be wrong. The other type of surveillance is upstream collection. And this actually we have a bit more information about. So in 2006, as I mentioned before, a whistleblower from AT&T came to EFF. He was a technician at AT&T, and he said, I have some documents. I have some documents about a project that I worked on while I was at AT&T at the Folsom Street facility there in San Francisco. And the documents disclosed that essentially what AT&T had done was place a splitter cabinet on their peering network and diverted an entire stream into a room that was controlled by the NSA. Within that room, the documents showed that there was a NARIS semantic traffic analyzer. And then leaving that room, there was a cable, there was a pipe that was somewhat smaller than the pipe that was going in. And that's the information that we had, and so on that basis, we filed suit first against AT&T and then against the NSA after the suit was dismissed in 2006. You all, I'm sure, are very familiar with how this works, so I can keep this, or I can skip this slide. So that's the 702 surveillance program. Two types, upstream and PRISM collection. The next is Section 215. Section 215 allows the government to ask the FISA court for the production of tangible things that are relevant to an authorized investigation. And the tangible things produced can be no broader than a grand jury subpoena, which is, a type of process that's used regularly in criminal investigations. And it only allows the FBI to apply for the order. Section 215 is what the government is relying on to compel the production of the calling records of essentially most Americans. The Guardian article disclosed that these orders were used to compel the production of telephony metadata created by Verizon for communications between the United States and abroad, and wholly within the United States, including local telephone calls. The information that they get is originating and terminating phone numbers, IMSI numbers, IMEI numbers, trunk identifiers, telephone calling card numbers, and the time and duration of calls. These orders are renewed every 90 days, and we believe, although it has not been confirmed, that these kinds of orders exist for 3 other companies, so you can use your imagination. Last week, actually, it was disclosed that the NSA also attempted to collect cell site location information under Section 215. They did a test run for for 2 years in 2010 and 2011, where they collected the location information of domestic calls. A separate program is the Internet Metadata Program. There's still relatively little known about this aspect of the program. It was originally, as I noted, it was done under inherent executive authority originally, but then shifted under FISA court in 2004 and 2005. But it was apparently ended in 2011. But again, this was a broad, bulk collection of Internet metadata. Domestic Internet metadata, too. And all these programs feed into vast databases that the NSA has. Pinwheel is their Internet content database. Nucleon is their telephony content database. Marina and Mainway are their two metadata databases. So that's where information from the domestic pen register program goes and the Section 215 program. X-Keyscore, so a number of other programs have recently been disclosed, and it's not entirely clear how these programs fit in. X-Keyscore appears to be what the NSA uses to conduct its surveillance overseas. So when it is actually intercepting the communications abroad. It's not clear if X-Keyscore is some type of interface or if it's actually the code name for all these various interception points that exist around the world. A Boundless Informant is another program that the NSA uses to track the amount of information that's collected from various countries around the world. It's a heat map, and if you note, the United States is as hot on that map as China. There's also the issue of the NSA's efforts to undermine encryption. So in the 1990s, as I'm sure many of you are familiar with, there was a public battle about whether the NSA essentially would have access to encryption keys, the Clipper chip you might remember from the Clinton administration. Ultimately, that was rejected, but what it turns out the NSA did was it went around and went ahead and did that in secret. So it undermined encryption standards with NIST. It compelled keys from various providers. It hacked into other providers to steal keys. And so ultimately the NSA, when their attempt to do something publicly was rejected, what they did was circumvent that and do it in private. And just last week, again, there was information disclosed about the NSA's attempts to undermine Tor. I don't know how many of you are familiar with Tor, but this was actually some of the most technically detailed information that's been disclosed to date. So if you're interested in what the NSA was doing to attack Tor, I highly recommend Bruce Schneier's article in The Guardian. But the takeaway was actually that the Tor application was pretty resilient, and that they weren't able to actually attack the Tor application. But what they did was they exploited vulnerabilities in Tor Firefox browser bundles, and through that they were able to do some tracking of users. I'm actually going to skip through a few of these. And so now I'd like to briefly discuss the problems. So you might be saying to me, you might be saying to yourself, you know, Mark, look, what you're talking about and what's been disclosed, yes, it demonstrates a very broad surveillance program, but there are national security threats, and this is the NSA's attempt to try and deal with those. And I'd say that to answer the question, you have to look at it in two ways. So the first question that you should ask yourself is are these programs legal? Are they consistent with statutes that are in force, and are they consistent with the Constitution? And then a second question that's equally important in my mind is, are the programs legitimate? Meaning, were they created in a way that is democratically legitimate? Did they involve all three branches of our government, and was the public able to participate in a full and informed and a meaningful way? And I think if you go back to the clip that I opened up with, I think that says a little something about the legitimacy question. But to answer the first, the programs, parts of the programs are illegal and they are unconstitutional. From 2001 to 2004 and 2005, the program operated in violation of a number of federal statutes, including the original FISA. It was also constitutionally suspect. It violated the Fourth Amendment and the First Amendment in a number of respects. And there's never been any accountability for that. No elected official has ever been brought to task for creating that program. But these programs, what's important to remember is these programs continue to exist today, right? So they may be smushed into existing legal authorities, but they're the same programs that operated under the Bush administration, and they're still illegal. Section 215, the bulk collection of telephone call records, that violates the Fourth Amendment, and in fact it violates the statute. The authors of the Patriot Act have come out and said that, look, when we authorized this statute, we did not think it authorized the bulk collection of all Americans' call records. In Section 702 surveillance, in particular the upstream surveillance that I talked about, where the NSA actually has access, direct access to companies' networks, there are significant Fourth Amendment problems there. Essentially, the NSA is getting everyone's communications and then filtering. And by filtering, that's also synonymous with searching every American's communications in order to pick out the ones that they're interested in. And the Fourth Amendment prohibits unreasonable searches and seizures. And then the other aspect, and I'm a transparency lawyer. I do national security work, I do government secrecy work, and I do electronic surveillance work. So the government secrecy side and the transparency side are what bother me incredibly about the program. And that's that it's absolutely illegitimate in the sense that neither the public nor the other branches of government were ever fully informed about the program's operation. So here's a quote from over the summer where the General Counsel of the Director of National Intelligence responded to a question from a representative. The question was, do you think a program of this magnitude, gathering information involving a large number of people involved with the telephone companies and so on, could be indefinitely kept secret from the American people? His answer was, well, we tried. That doesn't exactly inspire faith in the NSA or the intelligence community broadly, their commitment to involving the public in their decisions. It's the worst type of condescension. And repeatedly in this process, there has been repeated dishonesty under the guise of classification. Here's a quick example. So when the FISA Amendments Act was being reauthorized in 2012, it was originally scheduled to sunset because Congress said, look, if we're expanding this authority so broadly, we need to rethink it in 4 years, see if we actually need this program. And so when it was scheduled to sunset, Senator Wyden put a hold on the reauthorization so that the bill wouldn't move forward. And in exchange for releasing that hold, Senator Wyden got two statements declassified. One was that the Foreign Intelligence Surveillance Court had found that parts of the NSA's program violated the Fourth Amendment. The other was that the court had found that it violated the spirit of federal law. And that's all that was disclosed. The reauthorization debate came and went. EFF, after that information was disclosed, EFF filed a lawsuit trying to get the entire opinion disclosed so that the public could understand the court's concerns and intelligently debate the program. The law was ultimately reauthorized before we got access to the program. 3 days after the law was reauthorized, the government produced documents to us, and they were entirely redacted. Earlier this summer in August, the government finally released the opinion to us after we won in the Foreign Intelligence Surveillance Court and in the regular district court in D.C. And in the opinion were nuggets like this. The government's revelations mark the third instance in less than 3 years in which the government has disclosed a substantial misrepresentation regarding the scope of a major intelligence collection program. Or the court now understands that the NSA has acquired, is acquiring, and if the certifications and procedures now before the court are approved, will continue to acquire tens of thousands of wholly domestic communications. That's information that the public needed to have an intelligent debate about reauthorization, but the government intentionally kept that from us. Now I'll briefly describe what EFF is doing. We're involved in litigation. We've filed a lawsuit against the NSA. It's been ongoing since 2008. It's gone up and down to the Court of Appeals twice now, but it's still going. And we're challenging the upstream collection of Americans' communications. We filed a new suit this summer called First Unitarian versus NSA. It's a lawsuit on behalf of a broad coalition of groups, gun groups, religious groups, environmental groups, drug reform groups that are challenging the domestic call records collection program on the grounds that it violates their First Amendment associational rights. So their ability to engage with the public in support of their advocacy positions. And we also have two FOIA cases, Freedom of Information Act cases, where we're pushing for more disclosure, more information about the government's use of these surveillance programs. We're also pushing in Congress for a second church committee, just like the original one that really blew open the doors on the NSA in the first place, and for amendments to Section 215 and the FISA Amendments Act. And we're also our technologists, our in-house technologists, are trying to do a better job of encrypting the web. We put out a plugin for browsers called HTTPS Everywhere that defaults to HTTPS when it's installed. So, and I'd like to close with this. I'd like to, and I don't mean this in an antagonistic way, but I'd like to ask what you all are doing, what you all here at NANOG are doing. So if you sat through this presentation and you said, you know, that's not right what's happening, that looks like it might be illegal, or I should have been able to voice my concerns about this program before it was rolled out. I'd like to ask, what are you all doing? And I want to ask it to challenge you all, because you all are uniquely empowered in this world, in this situation, this electronic surveillance world, right? So Larry Lessig, in a book, Code and Other Laws of Cyberspace, he laid out the types of code that are going to govern our rights in the future, right? And he drew a distinction between West Coast code and East Coast code. And you all in this room are in the unique position of being able to exercise both, right? You have the ability to call your Congress, your member of Congress, call your representative, and express frustration with these programs, express your dissatisfaction with the programs, and at the same time you're able to build your networks in ways that are more resilient against surveillance, that can be more protective of privacy and that can enhance First Amendment rights and the right to speak anonymously online. So I'll close with this, and it's shifting gears a little bit, but I think it's particularly important to emphasize this point. So this case, United States versus Kincaid, was about the collection of DNA from federal felons convicted of certain felony offenses. And this is another case that involves the intersection of technology and law, only this time it's DNA and a DNA database. And the court, this was the Ninth Circuit Court of Appeals, found that the collection was constitutional as a condition of release from prison. And this is from the dissent. This is from a judge who dissented, saying, no, this should be protected by the Fourth Amendment. If I could, I'd like to read this. So, a decision like the majority's in this case that draws no hard lines and revels in the boon that new technology will provide to law enforcement is an engraved invitation to future expansion. And when that inevitable expansion comes, we will look to the regime we approve today as the new baseline and say this too must be okay because it's just one small step beyond the last thing that was approved. My colleagues in the plurality assure us that when that day comes, they will stand vigilant and they will guard the line, but by then the line, never very clear to begin with, will have shifted. The fishbowl will look like home. Let me tell you what happened after this decision. In 2004, it was federal felons convicted of limited offenses. After this, a number of states rolled out laws that required the collection of DNA from anyone convicted of any crime in states. And just last term, the Supreme Court upheld the collection of DNA from anyone arrested. So as you can tell, in the DNA context, the line that was never very clear to begin with started to shift. I'd say that now is our time to stand and guard the line in the electronic surveillance context. Now is the time for us to ensure that the rights that we've enjoyed for the past 50 and even 200 years are the same ones that we'll be able to enjoy 25, 50, and 200 years into the future. So thank you. I thank you all for having me here today, and I'm happy to answer any questions you all might have.
Do we have any questions in the room?
Oh, come on. I know some people have some questions.
This crowd has to have some questions. All right, Louis.
Thanks, Mark. Thanks, Dave. Louis Lee, Equinix. Will you be here the rest of the week?
Unfortunately, I won't.
Okay. So everybody, this is your chance. All right. And Mark, thank you very much for your work on this and other projects at EFF. I, for one, feel it's very valuable work. And you have the rare opportunity to address many of the network operators that were named in the recent revelations. So I don't know if you are even allowed by law to speak up, because I believe, if I am correct, that the request from the NSA is also classified.
Yes, so I cannot, as an attorney, I cannot encourage anyone to break the law. So I think if you do have particular knowledge of what I just talked about, I think it's unlikely that you would be allowed by law to talk about it here in a public forum. But that's not to say that you shouldn't go to your in-house attorneys and say, you know, I'm uncomfortable with this program, and encourage them to contact EFF. It depends on what company you work for, whether or not your company counsel will be interested in talking to EFF. But, you know, if there's something that you are aware of that you're uncomfortable about, you should definitely speak up. Who's next, Dave?
All right, we got the queue. Anton Capella, 5'9". Excellent presentation. Thanks for the summary. Along the same lines, I'm wondering if there's any document or cheat sheet that EFF might have which could help any size, say large or small, who doesn't have the luxury of staff attorneys who are technically equipped, like the EFF folks are. That would be helpful or useful in disseminating or sharing in this community. If you have anything like that, I'd put it to you to share it to the list if you could.
Yeah, you know, I don't think we have anything in particular about the NSA's program, but I should encourage smaller companies to reach out to EFF. We regularly counsel companies in some limited capacities. So
even mundane stuff like civil procedure, like what's lawful, what's not. You know, everybody tries to overstep their bounds, and most ISPs don't say no.
Right.
I would argue they probably don't know how. Right.
Right.
So if there's anything we could learn from you in a concise manner, we'd love it.
Yeah, absolutely.
Barry Rice with BioWest, over here.
Yeah,
Hi.
A couple of questions come up. One, countries outside of the U.S., what are they doing, and how are we impacting their civil rights? Second, you know, in a room this size, my real question is, how many people even know what the Fourth Amendment is here? You know? Then we're an odd group that maybe 30% know.
Right, right. So to get to your first question, the Constitution doesn't protect non-U.S. citizens, right? So the fallback against any surveillance regime is always our constitutional rights. But unfortunately, or fortunately, who knows, but the Constitution just doesn't apply abroad. So that kind of bulwark against government overreach doesn't apply. Essentially, the short answer is the NSA and the government can do basically whatever they want consistent with their own policies. So they have internal policies that say, you know, we'll only target people for foreign intelligence purposes, but that can be so broadly expanded that it can be meaningless.
Ungoverned
policies.
Yes.
Executive branch only. And to get to the second point about you know, people not knowing what the Fourth Amendment is and general unfamiliarity with our laws is, you know, that's a problem, and it's a problem that's particularly acute here, where we're dealing with both incredibly technical laws, very arcane laws dealing with electronic surveillance and national security, and there are serious technological issues. So, you know, at least you all have the benefit of doubt, or the benefit of understanding the technology issues that are at stake. But, you know, for most people, it's the double whammy of confusing law and confusing technology issues. So the public just closes their ears and don't get as involved in the debate as we'd like, and that's certainly something that EFF is trying to combat.
Just one real quick programming note. So we're going to run this till 11:30 and then pick up the agenda from there. And we'll have an updated agenda for this afternoon posted shortly. Just a quick programming note, because there's a lot of questions queued up and we want to make sure everyone can ask. So go ahead, Owen.
Going along Hurricane Electric. So as I understand things correctly, and I may be wrong here, there was surveillance with the phone companies handing over all kinds of records before there was a law to support it. And then you had a lawsuit against that. And there was a Foreign Intelligence Amendment Act or whatever that said, yeah, it was okay for the phone companies to do that. And that was the end of your lawsuit. Except, doesn't that violate the constitutional ex post facto prohibition?
We tried to raise that with the Supreme Court, and they were not interested. But yes.
Hi, Chris Woodfield with Twitter. Thanks for the talk. This has been a lot of really good information. I know it's so as far as what we can do to hopefully try to push back against this, I mean, it's very easy to say, call your senator or call your representative, donate to the EFF, but is there really any point? I mean, is there any hope on the horizon here? Are there any things that we can do maybe differently that might prove better paths, less resistance to getting these laws tightened down.
Yeah. So I would say that right now we're really in a unique position. Before Congress went on recess, a member of the House, Justin Amash, proposed the day before there was a vote, proposed to defund the NSA's call records collection program. That vote failed by, I think, 7 votes. And this was proposed the day before. Both leaderships in both parties was opposed to it. The White House was opposed to it. And yet it only failed by 7 votes. That's unheard of, right, for any type of amendment like that, let alone one that would significantly affect a national security collection program. Right now, I mean, as soon as the government funds itself again, but once Congress is back in session, there are a number of bills that are working their way through committees that are designed to take on exactly some of the problems that I talked about today. While you think that calling your representative or calling your senator doesn't matter, that is the one thing that actually does matter. Emails, they're pretty quick with the delete button, but if you can get somebody on the phone to listen to you, that really has a significant impact.
Thank you.
Thanks.
Okay, in the center here, and then we'll go to you, Tom.
My name is Andrew Sullivan. I work for Dine, but I speak for myself. In a previous job, I had the occasional title of Chief Wet Blanket Officer, so I'm going to try to challenge you here a little bit. We're in a world where British citizens have given up on habeas corpus, where Americans who fought a war of independence not to be searched and seized there anywhere they go, now cheerfully stand in line with their hands above their heads in airports. And will give just about any data about themselves to all kinds of companies, including some people who are in this room, probably my employer among them. Why do you think that this matters? Why not just give up and say, nope, we all live in public now because it's impossible to get away from this?
Yeah. And that's a question that we get a lot. So, and I have 2 responses to it. Right. The first is that the public has a vital interest in making sure that the government complies with the law, regardless of what law is being violated. In this case, it's an electronic surveillance law. But when we allow the government to flout the laws, it seriously threatens the rule of law within the United States. The second answer is generally I have nothing to hide, so why should I be worried? And my response to that, is 2 parts. So one is that just because people share information with companies doesn't necessarily mean that people want that information shared with the government, right? The Constitution doesn't say anything about the relationship between government, or it doesn't say anything about the relationship between people and companies. It says everything about the relationship between government and the citizens. So just because someone's willing to share their information with Google doesn't mean that they want the NSA to have it. The second part is, in general, people who say they have nothing to hide just haven't thought long enough about it. And if you think about giving someone total access to all of your information, at some point you will realize that no, in fact, there is a lot that I don't want to share, and that I don't share right now with both companies, other people, and the government.
Tom.
Thanks for the good...
Sorry, introduce yourself.
Oh, sorry. This is Tom Coffeen with Infoblox, but I'm speaking for myself here today. Thanks for the good, if eviscerating, presentation. My question is 2 parts, and the first is, if you can summarize what the existing whistleblower protections are for folks that are in a position to reveal when they might be, feeling like civil liberties are being violated in the course of doing their job. Second part of it would be, what is the EFF doing to clarify and improve, whatever those whistleblower protections may or may not be at this point?
So I might have to give you a pretty unsatisfactory answer, and that is that I don't know the scope of whistleblower protection laws. So the focus of my work is in government secrecy, electronic surveillance, and national security issues. I deal with the fruits of whistleblowers, but I don't actually deal regularly with whistleblowers themselves. There are fantastic organizations. The Government Accountability Project in Washington, D.C. has represented a number of NSA whistleblowers who've disclosed information. And you know, if there are questions that people have, they could direct them to GAP. And also, I'd recommend that if you have in-house counsel, or if you run your own shop, and get an order that you're not happy with, go talk to an attorney and go have that attorney come to EFF or the ACLU or an organization like that, and we'll be happy to help. And again, in terms of what EFF is doing, our mission is digital civil liberties. So, you know, I think expanding into whistleblower protection, we can't take on every battle, so that's not one that we've taken on so far.
Thank you.
Then last question in the center here.
Wayne Bouchard, Limelight Networks. In one article that I read not too long ago, it was revealed that there was a partnership between the United States, the United Kingdom, and I think it was Australia. I'd have to imagine that Canada's in there as well, though it wasn't explicitly stated, for basically open-ended and unrestricted access to the information that the NSA is gathering. So queries by foreign governments on the activities of American citizens without any warrant, without any due process, and without apparently any limits other than the query has to be submitted individually. That is, I think it's got to go through an intermediate party before it actually gets submitted. But can you address what the EFF is doing in that regard? Because I mean, that has to at the least be a violation of Fourth Amendment, and probably delving somewhat into the First Amendment as well.
Right.
Can you state what they're doing on that, and what the EFF knows about the extent of this and the possibility of other partnerships that may not have yet been disclosed?
Yeah. So there's no question that the NSA is sharing information with, it's called the Five Eyes. It's Canada, Britain, Australia, United States, New Zealand. The extent and the circumstances under which information is shared and those countries' intelligence agencies are able to conduct surveillance in the U.S. and the U.S. is able to do it in Britain or Australia or vice versa, that is information that we don't have a ton of information about so far. We know, we can say with a certainty that it's occurring and that it exists, but the circumstances are still unclear. And, you know, our push for a second church committee would disclose exactly this type of information, right? The full scope.
Do you know if records are being maintained of what searches are being done?
That, I believe they are. You know, that's what the NSA says. There's a big audit trail for every query that occurs, but, you know, obviously they have not shared that with the public.
Mark, thank you very much.
Thank you all.